participating in this campaign and speaking to other groups, and obviously most of the people we talk to are not nearly as well educated on these subjects as you are. So I'm going to just sort of go directly at the proposal and the way we think that it plays out, and then we can get to other issues in the Q&A period. We are pretty confident that there will be a ballot initiative placed on the ballot for the November 2012 election to increase Michigan's renewable energy standard to 25% by 2025. I'm going to go through the language with you in just a minute, but that's the core of it. It will be a constitutional amendment to Michigan's Constitution. Michigan's Constitution, unlike the U.S. Constitution, addresses policy issues as well as the processes of government. So we've got stem cell research, and tax limitations, and definition of marriage. I mean, any number of things that have been, done this way. It's aspirational in the sense that it sets the goal. It does leave it to the legislature and the Public Service Commission to set out the details of how we get there. And in that sense, is tailored to be appropriate to a document like the Constitution that simply says what we as a state, what we as a people want to accomplish. The requirement for a constitutional amendment done in this way is have 322,000 plus a few valid, non-duplicated signatures on the petition, and then that results in it being placed on the ballot fairly automatically, as long as the petition has been done right. And we've been through the State Board of Canvassers, so we're pretty sure that we're good on that point. So I think you should assume that this will be on the ballot. We are gathering signatures now. We're ahead of our schedule, so we're pretty comfortable with that. So I'm not going to talk anymore about election mechanics or anything, just the proposal. So here's the language. First, we say it's the policy of Michigan to promote and encourage the use of clean renewable electric energy sources, and we use the core of the definition that is in Public Act 295. PA 295 has a lot of subsidiary definitions explaining what counts and what doesn't. This neither overrides that in most cases, nor adds to it. There is room to legislate within this to either encourage certain options or prohibit them outright. The idea is simply that we go for this overall definition so that the idea of renewable energy can't be defined outright in Michigan. The core requirement is in the second paragraph. It is to have 25% of the energy, the electricity supplied by each of Michigan's electricity providers. That would include the industrial utilities and municipals, the co-ops, and the alternative providers in the competitive market. Have to come from the generation or purchase of electricity from renewable facilities located within Michigan or the service territories of Michigan utilities. This is the same geography that's in current law. It basically allows we, Indiana, Michigan, to produce within their service territories, or actually other utilities to produce within those companies' service territories in order to meet the objective. We encourage the legislature to provide guidance as to the schedule and encourage diversity of technologies, but that is something that needs to be determined in the legislative process. One change from Public Act 295 that we explicitly make is in how renewable energy is paid for. We simply say it should be paid for like any other electricity. So the per meter surcharge would not occur. It would just be volumetric, or whatever the standard of the time is, in the same way that we pay for any other electricity. And because of that change, and more generally to make sure that costs are reasonable for this purpose. We put a rate impact cap into the language. Now, because of changing from the per meter surcharge, the current cap, which is on the amount of the surcharge per meter by customer class, wouldn't make any sense. So we do it here as a percentage of total rates. So this is final rates. It's not just generation costs. It's distribution costs, everything, to the final customer. The intent, and it's hard to read these things and translate into utility regulation languages. The intent is not to squeeze the utilities on their normal returns, those kinds of things. It is also not something where we should have an accumulation of extra costs. The idea is that it's no more than 1% extra at any point in time over what it would have been without this proposal. This obviously invites legislative definition and clearly is the sort of thing that will be administered by the Public Service Commission. If this cost cap can't be satisfied and the 25% by 2025 achieved by any utility, we provide the off-ramp of them demonstrating that that's the case and being allowed delays, sort of on a one-year basis, but can be rolling as long as necessary. So we're saying that we believe that it can be done for this cost, and I'll illustrate that a little bit more in a moment. But if we are wrong, we're prepared to take longer to get to the objective of 25% renewables. Current law provides for certain incentives for using Michigan workers and Michigan manufactured goods in meeting our renewable energy requirement. We instruct the legislature to provide incentives for those purposes, though we don't say that it should be the current incentives necessarily. Every administration, legislature tends to want to do economic development, business attraction, and so on with its own flavor. If they want to use different mechanisms in the future, we're open to that. We simply ask that there be such incentives. And then finally, there are all sorts of ways that federal and state law can interact. And so against the possibility that there might be either a federal constitutional or statutory problem with any element of this, we simply instruct the courts to sever that part that's offending and do the best that can be done on the rest. That's the whole proposal. It's less than 300 words. Now, motivations. First of all, Michigan is behind many other states in both the degree of renewable energy that we have deployed and what we require. At least 20 states have renewable energy standards that are similar in concept to ours, but stronger in the sense of requiring more, a larger percentage of electricity to come from renewable sources than our 10% by 2015. The map here shows you the Midwest. Minnesota and Illinois are pretty similar to what we're proposing, 25% by 2025. Ohio isn't really quite a fair comparison because theirs allows a mix of efficiency and renewables and other kinds of things. Iowa didn't frame it as a percent of load. They have set their objectives in terms of capacity, but they're effectively asking their utilities to be at 25%, and they will be there in a couple of years. They're currently above 21%. California's targeting 33, Colorado 30, so there are some that are higher. Many of them started earlier than we did, so those are on schedules to occur at least as early as our proposed 2025. 16 states have done what we're proposing to do in the sense of adopting a renewable energy standard and then increasing it. So having gotten some experience with it, they said we want more. In some cases that's been done by voting people. Colorado has established and then increased the renewable energy standard by popular vote. So these are states that are, perhaps, we think, showing us the way.